Good afternoon. You're here, as you well know, for the panel on secrecy, quote, toward transparency. One of our panelists that's in your program wasn't able to make it because the Amtrak train simply didn't run. So that's Ann Beeson. So that allows us to let the remaining panelists speak at a little bit greater length, and perhaps the audience to have a little bit more leeway in asking questions. So we'll go ahead and begin. Just let me introduce a little bit the context of the panel, because the subject is itself so broad, secrecy, and there's so many facets to secrecy in the government, whether justified or unjustified. So as we all know, some secrecy is necessary to any administration. I think it was Cecily Bach who writes on lying, secrets, and various other topics along those lines, said once that governments have a primordial instinct about the need for secrecy. And so I think the real question that the panel will probably try to tackle is how much secrecy is too much secrecy, and are we currently suffering from an administration which has invoked secrecy too much? Now, there's several aspects. In fact, there's so many aspects to the notion of secrecy in the government, we can't possibly get to them all. But I will briefly relate the 3 or 4 that I have reason to believe the panelists will probably try to cover. The first was one, actually, that our first speaker will cover, but also that Ann Beeson was going to cover and won't be here, so we'll try to fill in. But I happen to know we have experts in the audience on it, and that's the so-called state secrets privilege, under which the courts can and do, on occasion, dismiss civil suits, regardless of their merits, regardless of the merits of the litigation, because of the risk of impugning national security if the subject matter of the litigation is exposed in a court proceeding. We've seen a couple recent illustrations of this, including the El Masri case about the person who was detained and subjected to extraordinary rendition, sent abroad, tortured. The Canadian government, among others, agreed that, first of all, he was not a terrorist, and secondly, that he had indeed been tortured. He attempted to bring a civil suit, was dismissed by the lower court in the Eastern District of Virginia, I think it was, went up on cert, and cert was denied. There are other examples as well. So the question in that case is, one, I think, has the invocation of the state secrets privilege escalated at an undue rate in recent years? And of course that requires considering not just the numbers, but also the fact that we are operating in a post-9/11 region. And has the court been too supine, as it were, in acceding to the government's requests that whole cases be dismissed, or even parts of cases be dismissed on the basis that the government tells them, usually in affidavits, that to continue with the case or particular aspects of the case would involve national security risks. So that's the state secrets privilege. A second aspect of secrecy in the government that's much debated, and has been debated actually for years and years and years and years through many different administrations, is the overclassification problem. That's in a few years ago, that's the last year for which I have any statistics, the government classified 16 million pieces of paper, which was double the rate from the 2 years before. When they classify something, that renders it inaccessible to the public generally, to the press, and even to suits that are brought under the Freedom of Information Act to try to get access. Here again, the focus is on very much originally what the standards for classification are, and each new president gets, I think Meredith will go into this, Meredith Fuchs, each new president gets the right to write a new executive order on classification. And some of the standards in these orders have differed over the years. So once something is in an order, though, and somebody tries to bring it, a suit under FOIA to get access to it, FOIA Exemption 1 says that the court decides whether or not the document has been classified pursuant to the executive order, but also whether the classification is a reasonable one. Again, the courts have been very, not just in this administration, but previously, quite dormant in exercising that privilege very vigorously. So we have an enormous amount of classification, and what everybody agrees would be over. I'll just give you one quick quote from Peter Goss, the late head of the CIA, who said, and I quote, "If I get a piece of paper on my table and I'm not sure what to do with it, and in fact there may be a confidence, I will put a confidence stamp on it and I'll put it in the confidential box. Then I won't have to worry about whether I've released something that was classified, that should have been classified or not." And so I think that that gives us the incentive to do the wrong thing, and something ought to be done about it. It quickly becomes apparent, he said, to anybody who has considerable experience with classified material that there is massive, this is from Peter Goss, massive overclassification, and that the principal concern of the classifiers is not with national security, but with governmental embarrassment of one sort or another. There may be some basis for short-term classification while plans are being made or negotiations going on, but apart from details of weapon systems, there's very rarely any real risk to current national security from the publication of facts relating to transactions in the past, even the most recent past. So the question of overclassification is a second aspect of secrecy, which I think we'll be able to touch on. The third, I mentioned very briefly, is invocation of executive privilege and its partner deliberative privilege to bar White House and sometimes other non-White House government officials from either answering congressional inquiries or even, as is apparent in the current suit dealing with subpoenas of former government Bush administration officials in the U.S. attorney firing matter, from even appearing at the congressional hearing pursuant to subpoena. Now finally, and I think Jeff Stone is going to touch on this, is the question of the press's role in all this. Our original founding fathers actually thought that basically in the national security area, as in other areas, the vitality of the democracy was going to depend upon the action and the confidence of the people, which was in turn going to depend upon the information they got. When they don't get the information, and they get their information now from blogs as well as from TVs and from newspapers, but when they don't get the information, it's very hard for them to make informed choices in a democracy. The question arises whether, as some have claimed, this administration has been more aggressive than former administrations in going after newspaper people who, having been frustrated with not getting their information directly from the government, go find their own confidential sources and then seek to keep them confidential. There are other aspects to secrecy which we probably won't get around to looking at, but I think one overall theme as people talk would be we are on the cusp of a new administration, and what are the steps, the priority steps that a new administration may want to take in order to do, as I suspect, no matter who the president is, they will say they want to have an open and transparent administration. They all do. But if that is a sincere desire, what are some of the priority steps that we would suggest? And I know, among others, that Jeff Stone has written an issues paper on this, so this will be a splendid opportunity for him to give us a preview on that. Okay, just a word on the order in which we're going to go. You've got good biographies of all the panelists, including the absent ones, in your materials, but I'll tell you the order in which they will go. I think first will be Richard Samp, who's down there at the far end, who's the chief counsel of the Washington Legal Foundation, and that's a foundation which has litigated, and he, I believe, has personally litigated against excessive regulation and in support of a strong national defense. He also litigated as an amicus in the recently decided Boumediene case, in the Hamdi Padilla cases, and in several other cases, and he's a graduate of the University of Michigan Law School. Meredith Fuchs, to my immediate left, is the general counsel in the National Securities Archive at GW. She's formerly a partner at Wiley, Ryan, and Fielding. She was also a law clerk to Judge Friedman and to me, and she's a graduate of the NYU Law School. And after that, Jeff Stone, who's the Edward Levy professor at the University of Chicago Law School, formerly its dean, and the provost of the university. Aside from the issues paper on this very subject that he's written, he's also written books on free speech, and he was a law clerk to Justice Brennan. The format we're going to use is that in the order that I've just described, the panelists are going to give you, because we have such a widely faceted program here, a between 7-9 minutes, shorter if they want, preview of a particular aspect, one of the ones that I've described. After they're through, we're going to have an exchange, or let the panelists pick up from the other panelists those aspects on which they either want to comment or to question, so that we'll have some intra-panel dialogue, and the last half an hour we'll save for your questions. With that, Samp?
Thank you. I plan to focus my comments on the state secret doctrine. Judge Wall didn't mention it, but she testified recently before Congress regarding possible legislation to refine the doctrine. Her suggestions were all very thoughtful, and I find myself in agreement with many of them. Where I suspect I part company with her and the others on this panel, particularly Ann Beeson, who was not able to make it down from New York, is our assessment of whether the Bush administration has abused the doctrine and whether the string of recent court decisions that have upheld the doctrine have imposed inappropriate roadblocks to civil litigation. As you may know, Ann Beeson represented the ACLU in the Sixth Circuit in the recent challenge to the TSP program. In my allotted minutes, I only have time to briefly summarize what the state secrets doctrine is about. Although it has been formally recognized only since the 1953 Reynolds decision, its origin goes back more than 200 years. Evidentiary issues that arose in both Marbury versus Madison and the Burr treason trial turned on executive privilege claims that we see today as precursors to the state secret doctrine. Underlying the doctrine is the belief that there are instances in which the need to maintain secrecy of government information, usually military and national security information, is so strong that it cannot be divulged in court proceedings, even if the result of continued secrecy is to derail the litigation. I am unaware of anyone who disagrees that there are at least some such instances. The only disagreement is over where one draws the line. The consequences of maintaining such secrecy varies depending on whether the proceedings are civil or criminal. If criminal, courts often require prosecutors to drop their charges if continued secrecy will prejudice the defense. If civil, invocation of the state secrets doctrine entails requiring the defendant to try to make, the plaintiff to try to make his or her prima facie case without the evidence in question, and in some cases requires dismissal of the lawsuit. The defendants in civil cases typically are the federal government itself or its employees or those who contract with the government. The paucity of state secrets cases prior to World War II is not surprising because suits against the government were quite limited until adoption of the Federal Tort Claims Act in 1946, and constitutional claims against government employees were not authorized until the Supreme Court's Bivens decision in 1971. As I mentioned, the doctrine was first clearly defined by the Supreme Court in 1953 in Reynolds, an FTCA wrongful death suit brought against the United States by widows of several men who died in a B-29 crash in Georgia. The plane had been on a mission to test classified radar equipment. During the course of litigation, the plaintiff sought production of a report drafted in connection with the Air Force's post-accident investigation. The Air Force resisted production, claiming that disclosure of the report would risk disclosure of state secrets. And it even wanted the courts to view it didn't want the courts to review the report in camera. In its decision, the Supreme Court, speaking through Chief Justice Vinson, established many of the rules governing the state's secrets doctrine that are followed today. First, Vinson made clear that the issue of disclosure is always justiciable. So courts can never be told that it's not their business to look into this issue. Second, a series of formalities must be followed by the executive branch to reduce the possibility that the doctrine will be frivolously invoked. In particular, the claim of privilege must be asserted by the official who is the head of the department resisting discovery. Third, courts generally are entitled to review relevant documents in camera. Fourth, Vinson recognized that in general courts lack the institutional competence to second-guess an executive branch decision that disclosure would damage national security. Thus, the courts are to adopt deferential review after taking a close look at the evidence. They should uphold the privilege so long as there is even a, quote, reasonable danger, end quote, that compulsion of evidence would harm national security. The court upheld the Air Force's assertion of privilege. It thought that the plaintiffs could obtain the information they needed through depositions of those who knew something about the crash. In the succeeding half-century, Reynolds has been applied generally without great difficulty. The biggest problem with the case itself is that it later turned out that the Air Force may not have been fully candid about what was in the report. The report discussed negligent acts that led to the crash, but it said virtually nothing about the experimental radar system that was on board the plane. So it is highly unlikely that the report's release would have endangered national security at all. The revelation of the Air Force's lack of candor highlights the need for in-camera review of documents by reviewing courts. Had the accident report in Reynolds been examined in camera, which Vinson said should be the normal procedure, the trial court probably would have determined that there was no reasonable danger to national security posed by release of the report. And indeed, in more recent cases, judges generally have conducted an in-camera review. So what about claims that the Bush administration has been abusing the state secrets doctrine by invoking it indiscriminately? Those claims are not borne out by the evidence. For anyone interested in a detailed and balanced examination of the issue, I recommend a 2007 Law Review article written by Professor Robert Chesney in the George Washington Law Review. The article examined every reported federal decision over the past 60 years through 2006 that has invoked the state secrets doctrine. He concluded that a significant number of reported decisions did not start appearing until the early 1970s. Since that time, there has been no appreciable change in either the frequency or manner in which the doctrine has been raised. The doctrine is being raised today in two high-profile areas: cases alleging extraordinary rendition to foreign countries, and cases challenging the Terrorist Surveillance Program, or TSP. I recognize that this would be a wildly inappropriate forum for me to launch into a defense of either program, so I won't be so foolhardy as to attempt to do so. But however one feels about these programs, I do not believe there can be any serious challenge that both programs involve closely guarded secrets whose release could do serious diplomatic damage or perhaps national security damage to the United States government. If one objects to rendition programs, which began in 1995 during the Clinton administration, or the TSP, which began following 9/11, the appropriate forum for those objections is the halls of Congress, not the federal courts. Federal courts, including the Fourth Circuit, the Sixth Circuit, and a very liberal panel of the Ninth Circuit, have agreed with me. In each instance, the court ordered the dismissal of tort actions filed against the federal government, federal officials, and/or federal contractors because the continuation of the suits would not be possible without revealing important state secrets. Indeed, the revelation of those secrets was the very purpose of most of those lawsuits. I would be happy to discuss any of those suits during the question and answer period that follows. The important point is the Bush administration's invocation of the state secrets doctrine in these cases and the court's acceptance of the administration's claims was consistent with case law stretching back for centuries. The principal concern raised by the plaintiffs in these cases is, unless the courts step in, there will be no judicial check on government lawlessness. The courts have answered that concern appropriately by pointing out that they do not possess a roving commission to overrule the other branches of government. Rather, they are confined to deciding cases and controversies. If the result is that some people are not having an opportunity to have their damage claims heard in the courts, Congress and the President are free to establish alternative, more private forums to consider such claims. That was the state of affairs before the adoption of the FTCA in 1946. So what reforms are possible? I agree with Judge Wald that judges should in general be encouraged to examine relevant and available documents in camera. I think Congress should consider requiring the executive branch to report annually the number of times it invokes the state secrets doctrine each year. Right now, there is no good list quantifying how often the doctrine is invoked. While Congress is free to tinker with the standards to some extent, i.e., it may do so up to the point that it does not interfere with constitutionally protected executive privilege, I don't encourage it to do so. Instead, it is ultimately up to Congress to use its oversight capabilities to eliminate any executive branch excesses that it may believe are taking place. Thank you very much.
Thank you. I'm going to put on Ann Beeson's hat for just a minute, just to sort of fill out the picture here a little bit, and then we can go back and forth later on. I think it's just a couple of things I want to point out. One is I am familiar with Professor Chesney's article, and I certainly have not done the original research to be in any position to question his conclusions. I will simply point out to you that the state secrets privilege is the subject of two bills in Congress. We have somebody who's an expert on the House bill in the audience, and I hope he'll participate in the audience questioning later on. But the bill in the Senate has actually gone through the Senate Judiciary Committee. The American Bar Association has testified in favor of the bills with, minor suggestions, revisions in both houses. They're being expressing the concern of them as well that, in fact, many civil suits that might be preserved in whole or in part are being thrown out with the invocation of the state secrets privilege. The legislation basically doesn't suggest that if the state secrets privilege, if there really is important national security information that does pose a significant risk to national security, that it has to be released. But it sets forth a number of steps that the judge has to do, including looking at the material which were agreed upon, but also allowing discovery on the allegedly national security information to see how much of the suit could remain if you never even had to get into the problem of national security, and then adopting many of the provisions or analogous provisions in CIPA, which is the Criminal Intelligence Protection Act, which says sometimes if there is national security information, then the judge could order the government to give a redacted version or a substitute version which doesn't violate the national security, or statements of stipulations of facts, again, so that the lawsuit can proceed to go on. Now, I'm in no position to say how many of the dismissals for national security state secrets have really been justified or unjustified, but, one has to wonder, and it came up many times in the hearings on the El Masri case, where this man did suffer, torture and various other things for a period of years, and had the whole suit dismissed right up front, without any sort of preliminary proceedings to see if maybe there wasn't some way you could go ahead with something analogous, I say, to the CIPA Act. So this bill is in both houses of Congress. My understanding is that the administration opposes it. And the question, just so you're aware, that some of the key questions that are being raised in the hearings are, one, this is a common law privilege which the courts originated in the courts, but some of the decisions have talked a little bit about, in dicta as it were, about it having constitutional roots. So the allusion that Mr. Camp made about how far you can regulate, is there any limit on Congress's power to regulate on how an evidentiary privilege like this can or should be applied by the courts? That's one question which has arisen. As you well know, Congress has regulated on numerous other evidentiary privileges. Another one is a question also raised in Mr. Camp's talk, which is what's the standard? I mean, everybody agrees the court has the ultimate power to decide whether or not a significant risk has been raised by the government's affidavit and its own looking at the material. Then the question comes vis-a-vis the affidavits or vis-a-vis the government's testimony. Hey, this is a national security privilege. And the question that's raised about the court's institutional competence to decide whether it is or not. Should it give, as the government has testified, utmost deference to the government's appraisal that it is national security information? Should it make its own independent judgment, as some of the legislation that's in Congress suggests, pointing out that courts, do all sorts of things that they may not have been trained to do in terms of complex matters, complex governmental matters, and that they are equally well equipped. And they make decisions about classified material and national security concerns all the time. So why should they not have the competence to make this decision as well? The bills have a much lower threshold of the weight that they would give to the government's appraisal than utmost deference. Well, that's just to sort of put this state secrets thing in privilege. And Meredith?
Sure. Thank you, Judge Wald. And I just wanted, before I start, just thank the American Constitution Society. I remember coming to my first ACS conference several years ago, 3 or 4 years ago, and feeling very empowered to hear progressive lawyers advance their positions about, having a system of checks and balances that actually works. And it was nice to know that there were other people who thought that way, so I'm very honored to be here. Government secrecy and open government issues are absolutely fundamental to making our system of checks and balances work. And I should explain, for those of you who don't know what the National Security Archive is, which is the organization I work for, that despite the sound of it, and despite that some people call it the NSA, we're not the NSA. We're the National Security Archive, and we actually try to wrest government secrets from government agencies, often historical secrets, but for the analysis that my colleagues do about national intelligence policy and military policy. So all of these issues about secrecy are very central to the work that we do, and we spend a lot of time in our advocacy work thinking about why open government is important. In government secrecy, while it's always a critical issue because it determines whether or not we can have an informed populace in this country, it's especially critical in a year like this one when we're electing a new national leader. And we have an opportunity to tell that leader, whether it's Senator Obama or Senator McCain, that they are only going to be one part of our system of government, and that they cannot leave out the other branches of government, nor can they leave out the public. And that's an especially important thing to consider in an election year when we have to actually go out and say what we think. And if we don't know what the government is doing, we're not going to be able to fulfill our responsibility as voters. So I've been asked to talk a little bit about classification, and Judge Wald already set out some of the basics, and I'm going to add a couple of basics to your knowledge about that and then talk a little bit about what's happened with classification policy in this administration. First of all, as Judge Wald mentioned, the classification policy is one that is essentially set by the President, and it comes from the President's Commander-in-Chief authority. However, I would argue that that power is not exclusive to the President, that Congress has some authority in the classification area. And the President, each President revises this executive order on classification. Well, what did this administration do? When President Bush amended Executive Order 12958, he actually removed several provisions that were in there that would have instructed government classifiers to err on the side of lower classification levels, err on the side of shorter duration of classification. And what's troubling about that is that there was a reason those provisions were in there. Those provisions had been hard fought during the Clinton administration in order to try to put in some internal balancing when classification decisions were made. Courts do not play a very strong role in overturning classification decisions, and that was one of the ways to try to ensure that the decisions were made with a bit more judgment, because we knew courts were not going to really be ordering secrets to be released very often. So that's number one. The President really does set this policy. The second basic, I would say, is that everyone agrees that some classification is necessary. Some things have to stay secret. Whether you're negotiating a treaty, or you're in the middle of a law enforcement investigation, or it's, you know, the numbers you need to get into the nuclear vault, those things have to be kept secret. We understand that. But on the other side of that, everyone pretty much agrees that there's massive overclassification. Judge Wald mentioned Porter Goss's statement. Well, he's the former chair of the House Permanent Select Committee on Intelligence, former CIA director. He's not the only one who, while in a position of significant responsibility, would say there's overclassification. The Secretary of Defense, Rumsfeld, said that there was massive overclassification while he was Secretary of Defense. And I didn't bring my list of quotes. I'm glad Judge Wald read to you what Porter Goss actually said. But, you know, as you look throughout the executive branch, everyone would agree. In fact, classification decisions, which were about 8.7 million in 2001, were up to 20 million in 2006. And the cost is significant. The cost went from something like $5 billion in 2001 to $8 billion in 2005. Most recent, I don't have more recent statistics than that, but it's obviously a significant cost to the public. And if we're overclassifying, then some of that money could be better spent on classifying the real secrets and protecting them instead of protecting things that don't need to be secret. So why is there such overclassification? Again, Judge Wald's, the quote that she provided to you gives some indication for that. I think another place to look is a quote that Erwin Griswold, the former Solicitor General of the United States, gave years after the Pentagon Papers case, when he basically said that that there's many reasons for secrecy, from administrative convenience to cover-up of embarrassment, but very rarely is it because actual secrecy is needed. In fact, there's sometimes even secrecy is used to cover up government lies. And I think the Korematsu case, which I'm sure many of you who are still in law school and just took constitutional law have learned about, is shocking for so many reasons, only one of which is how the government treated people of Japanese ancestry in our country. But it's also shocking because years later, under the Freedom of Information Act, people were able to learn that it was based on a lie. It was based on a lie that the military actually had evidence that there had been signals sent by people of Japanese ancestry off the coast of California. So sometimes the government lies, probably not all the time. Sometimes the government just overreaches. Mr. Sam talked about the Reynolds accident report. I actually I have a copy of that report. It's this big, and I've read it. I saw nothing in it that suggests it was a secret, but I talked to one of the government lawyers who represented the government in the recent appeal. After the case, after it was exposed, after the accident report was exposed, the original plaintiffs they went to the Supreme Court and they said the court was lied to, and the case went back down on appeal. And I spoke to one of the government lawyers, and she insisted that she thought there was a code word somewhere buried in there. But, and the code word would be, something that would be protected, but it's this big, and honestly, she wasn't able to show me the code word when I confronted her with it. So sometimes there's just overreaching. I mean, the court in that case ultimately did say that it would have exposed the fact that our military was trying to make pilotless aircraft, and they didn't want the Soviets to know that. Although that was not actually what was argued by the government when the case was originally brought to the Supreme Court. So there's a lot of overclassification and a lot of reasons for that, some bad and some worse. And why does that matter? I mentioned the cost, but obviously the cost isn't the only thing that matters. I mean, the truth of it is that too much secrecy actually can harm our security. And that's one of the central conclusions that the 9/11 Commission reached in its report. When they found, or they concluded, that if there had been more publicity about some of the work within our country, identifying, for example, this FBI memo that said that they were concerned about Muslim radicals who were at flight schools in the United States, or if the arrest of Moussaoui had been publicized, those kinds of things might have prevented the attacks. And that's a central conclusion in the report. And one of the reasons the 9/11 Commission stressed the need to share information. we have to improve information sharing, they said. Well, it's fine in retrospect to look back and say that was a big mistake, but and we don't really know, obviously, what would have happened. But there's other decisions that we can look at, and we can examine how the secrecy interfered possibly with good decision-making, or at the very least allowed us to go ahead and do things that we might have not done so quickly had we not had secrecy as an excuse. For instance, the decision to go to war was one where secrecy really, I think, interfered with adequate consideration of our national interest, our national situation. In that case, members of Congress asked for the intelligence establishment to produce a national intelligence estimate about Iraqi weapons of mass destruction that was to be provided before Congress was going to vote on the authorization. I'm told I'm going too long. The authorization to go to war. And in fact, that was produced. And how many members of Congress do you think actually read that national intelligence estimate? Well, certainly no more than 10 is what we know. And why? Because of the secrecy. Because you had to go to a SCIF, you had to sign in, you had to read it there. And also because an unclassified version was also released, so they could get away with reading that. But that unclassified version didn't include any of the concerns or caveats about whether or not Iraq had a good operating WMD program. So the secrecy becomes the excuse, I think, for not actually having sufficient analysis and dissent. Okay, I know I have to cut off. I have two quick things to mention. I'm not going to talk about NSA surveillance, but maybe in the Q&A we can talk about that. Recently, the President issued a memorandum on a new category of information called controlled unclassified information. I want to mention that because this is a new type of description for information that the public is not going to be able to just get because it's controlled. Well, what does that mean? It means that it needs to be safeguarded because it's all about our homeland security. Well, I just want to point out a couple of things to show this recurrent theme in this administration's policies. In that program, even though it's been widely accepted that controlling information interferes with information sharing, there is nothing in the President's new policy that would reduce secrecy. And in fact, there's things in the policy that could harm our ability to ask for information under FOIA. So that's troubling enough. Even more troubling is there's absolutely no recognition that there's certain instances when members of the public might have the need for information, regardless of whether they make a FOIA request. So when you're talking about Homeland Security information, what does that mean? Well, what if there's a threat to your community and the first preventers and first responders are not going to be able to help you? Shouldn't the Department of Homeland Security feel free to let you know so you can protect your family and your community? Well, this policy may mean that they're not going to be free to tell you those things. I think it's very troubling. And the last thing, just to get in my pitch, for what I think is really indicative of the policy of this administration about secrecy is the disappearance of millions of emails in the White House. And this is not a classification policy, but I think it shows, a sort of unwillingness or a lack of feeling obliged to be accountable to the public. Because at the end of the day, if you can't find out what happened or why it happened, then you can't fix those problems. I think, Judge Wald asked us to talk about the next administration, and I'd be happy to tell you specific ideas. But I just want to say that, as we, choose our next president, we have to make sure they understand that the power we're giving them is loaned to them, and that in the end, it's our country, and that we are entitled to know what the president's doing as he conducts our national affairs.
Thanks. Jeff?
So, as Judge Wald said, I'll talk a little bit about the role of the press in all of this. And let me begin by making a fairly obvious point, which is that in an ideal world, the decision we would make in judging whether to keep something secret or to allow it to be disclosed generally to the public would be essentially to weigh the benefit of the disclosure to public discourse and self-governance and accountability on the one hand against whatever harm to the national security the disclosure of the information might pose. And from a legal standpoint, it might seem fairly straightforward that, okay, that's a balancing question and somebody simply needs to strike that balance. One of the things that's interesting about this area of the law is how completely unremoved from that simple inquiry the various legal doctrines have become, and also institutionally that why that has evolved the way it has. The vast majority of the problem can be captured by a simple hypothetical. Suppose the government has done an investigation of nuclear power plants in the United States and determined which ones are most vulnerable to terrorist attack and precisely what ways they are vulnerable to terrorist attack. And it has produced such a document. And the question now is whether to disclose that information to the public. There's obviously considerable public value in having that information because there can be correctives that are taken. Individuals who live near those nuclear power plants can make important life decisions about whether they want to stay there. To the extent that the fact that these particular vulnerabilities haven't been addressed previously, public officials can be held accountable. On the other hand, releasing the information obviously would inform terrorists that there are vulnerabilities that they could then take advantage of. What that hypothetical makes clear is that stating that the issue is balancing X against Y is a lot easier than actually balancing X against Y. In fact, these are two incommensurables. It's very difficult to know how to think in a coherent way about what is the public value of that information relative to what is the danger of disclosing that information, let alone to balance the two against each other and to say that, okay, we know the answer. There's a right yes or no answer in terms of disclosure or confidentiality. Okay, almost all of this problem does not involve the press. the important thing to understand is that virtually all of the decisions that are made in the United States about whether we know or do not know information that the government is inclined to keep secret is made invisibly and has nothing whatever to do with the press or with us as citizens. It's made through the classification process, and it's made by somebody with a stamp who basically says better be safe than sorry, as any of us would do in the same situation. And when faced with the risk of classifying something where it gets buried and no harm ever comes from the fact of classification, or letting it go out, take the list of the nuclear power plants, where maybe that would lead to a terrorist attack, almost anyone is quite sensibly, as Goss suggested, to stamp top secret and put it in the drawer and avoid the public difficulty. And as Judge Wald noted, adding to that is the very large factor that anyone who's been in any position of authority or believes they were in a position of authority knows. Once you're in a position of authority, you want to be able to control information. Because you don't want to be criticized. You don't want them to know all the things you're doing. They'll just screw it up anyway, and they'll second-guess you. And so if you can keep things secret, you always want to keep things secret. So there are huge incentives to bury information if you can control it and if you can do it effectively. The practical reality of the classification system is that virtually anything that the government wants to keep secret, it's stamped secret, and it puts it in a drawer, and nobody ever knows about it. Unless the government itself decides it wants to reveal the information. So the press is really not a player in any of this in 99.999% of the situations. And that's a real problem because it means it's all going on invisibly. And this really goes to the issues in particular that Meredith was addressing. So when does the press come into play in this? Well, the press comes into play, of course, most often when the press happens to get its hands on a particular item of information that the government would like to keep secret. And I want to briefly address two aspects of that situation. One is, suppose the press does get its hands on such information that has been classified as secret. What happens if it decides to reveal the information? Well, the answer to that, it turns out, is reasonably clear under existing law. This is an issue we've had a few debates over historically, and they've been resolved pretty definitively. When we first entered World War I, when the Wilson administration proposed the Espionage Act of 1917, one of the provisions it proposed would have made it a crime for any member of the press to publish information that the president had decided the secrecy of which is necessary for the national security. And after an extensive debate on this issue, Congress rejected the provision, even after the administration specifically appealed to Congress that this was essential to the well-being of the country. Congress rejected the idea that the executive branch should have the authority authorized by Congress or otherwise to punish members of the press for publishing what the press decided was in the interest of the public. And the legislation, therefore, was defeated. The second major issue that we've seen on this question, of course, was the Pentagon Papers case, where the Supreme Court held that the effort of the Nixon administration to enjoin the publication of the Pentagon Papers would have violated the First Amendment, holding that in the absence of clear and direct evidence of immediate grave harm to the national security, the government could not enjoin the publication of information on the plea that the publication might endanger the national security. And then most recently we had somewhat of a debate over the New York Times publication of the existence of the National Security Agency terrorist surveillance program, after which the Attorney General and various members of Congress threatened criminal prosecution of the New York Times and of the reporters involved, but ultimately nothing came of that because there is, in fact, a pretty clear consensus, I think, in the law today that the New York Times, that the New York Times versus the United States, the Pentagon Papers decision, although it came out in the context of a prior restraint, would almost surely be the standard that would have to be satisfied in the context of criminal prosecution as well, and that as a practical matter, criminal prosecution of the press for publishing classified information is pretty much of a null set in the United States. It has never happened in the entire course of American history. So if the press gets its hands on something, which is difficult, and chooses to publish it, we in fact have very high constitutional protection, which is quite anomalous when you think about the fact that if it doesn't get its hands on it, we have absolutely no right to learn the information in the first place. Okay, the second issue then involves this question of journalist source privilege, which is sort of in the middle of this process. So the government has virtually absolute authority to prevent the disclosure of information it is determined should be classified. But if the press gets it, it has virtual carte blanche to publish it. So then you get the situation where a government employee or some other source has revealed classified information to the press, which it then publishes and which it has a First Amendment right to publish. The question then is, well, can a court order the reporter to reveal the source of the information so that the government can investigate and ultimately prosecute the individual who unlawfully revealed the information to the press that the press had a First Amendment right to publish? On this question, the Supreme Court in 1972 in the Brandsburg case in a 5-4 decision, actually a 4-1-4 decision, rejected the argument that there was a First Amendment privilege in this context, holding in effect that it would be too difficult as a First Amendment matter to determine constitutionally how to define the press, that is, who would in effect be able to assert such a privilege, and therefore found that there was not sufficient need for such a privilege based on the First Amendment to justify such an interpretation of the Constitution. In the years since then, 49 states and the District of Columbia have adopted, either by statute or by state constitutional interpretation or by common law, a journalist source privilege, the only exception being Wyoming. But there is no federal privilege. And currently pending in Congress is legislation, the Free Flow of Information Act, that would create a journalist source privilege, the rationale of which is quite similar to the attorney-client privilege or the doctor-patient privilege. The basic notion is that we, in general, want people to disclose information in certain circumstances. We want them not to be afraid that if they disclose the information and they need confidentiality or feel they need confidentiality, that they'll be deterred from doing so. And so a privilege is a way of providing a cloak over that communication. Congress has, up to this point, refused to enact such legislation, partly because when it's been proposed in the past, members of Congress or members of the executive have immediately raised the flag of national security and said that a privilege would undermine national security, in response to which members of the press have always said, if we don't have an absolute privilege, we don't want to play. And so whenever in the past the idea of a journalist source privilege in the form of legislation has come up, it's been defeated. Finally, I think now, after the debacle involving Valerie Plame and Judith Miller, there's been more of a sense on the part of the press of a willingness to accept a qualified privilege, which would essentially provide a journalist source privilege for most situations, but would in fact allow the privilege to be overridden in cases where there was a serious danger to national security. That bill has passed the House and is pending in the Senate. It's been opposed by the administration. It's a very modest bill. It goes no further than the law in 49 jurisdictions in the United States, which have had such laws in effect for quite some time, many of which are absolute, others of which are qualified. If one looks for a piece of legislation that could do some good in this area, and do so in a way that does not appreciably jeopardize national security, then the Free Flow of Information Act, I think, was a simple solution to improve the situation, at least at the margin.
Okay, I think what we're going to do now is have one round at least of panelists. It's pretty hard because of the interest and the breadth of the subjects addressed, but let me start with Richard Samp, but let me just clue you into one question I have as you proceed on your own agenda, and that is you talked about relying upon congressional oversight as a alternative to changing the rules of the state secrets privilege. One question that certainly has occurred to me is that there has been a fair amount of reticence on the part, at least of this administration, and I think of some prior administrations as well, to give Congress any kind of information. We're now, of course, having the fight over the information and the appearance of former administration officials before the House Judiciary Committee investigating the firing of the attorneys. But also, the torture memos were not disclosed until they were leaked, actually, in the Abu Ghraib and all sorts of things. How can Congress be a relevant and effective monitor if the President or the administration isn't fairly open with them under, what are reasonable restrictions, I guess, on national security? Okay. You don't have to answer my question first. You can do your own first. And
Well,
add it
I
on.
do think that if there's going to be effective congressional oversight, there has to be a fair amount of sharing information. Now, in terms of the programs that we are talking about here, in particular the terrorist surveillance program, my understanding is that the relevant committees were fully briefed, so that in terms of basic factual information, it's not a problem of sharing information. Now, some people say, well, the circumstances under which they get the information make it very difficult for oversight to take place, and that may be true. However, the opportunity is nonetheless there. Now, in terms of specific documents being turned over, I think that's a totally different question. Just as I think it's a very good thing that we allow a certain amount of congressional privilege, and we don't allow the FBI to take out every single document out of Congressman Jefferson's office. We also have a certain amount of executive privilege, and so the idea that there ought to be some deliberative process privilege, that there ought to be some right of the executive branch to withhold documents that are not basic factual information, but rather are simply documents in which people are spelling out either their thoughts about what policy should be or else their legal justifications for a particular policy. That's not the same sort of document that we've been talking about here, and I don't want to get into an extended discussion on executive privilege, except to say that it seems to me that the kinds of documents that we're talking about primarily here today about state secrets are documents which I think generally have been shared, and to the extent that people can demonstrate to me that the executive branch didn't share particular documents with Congress, I'd like to know about it, but I think that those would be few and far between.
Well, as I recall, just to do an anecdote, wasn't it Senator Rockefeller who said he was one of the so-called Gang of Four? There were two intelligence people from each of the intelligence committees that could see certain documents, but that he saw one document, wrote something about it, and put his own notes, since his staff couldn't do it, into a safe and kept them there for a year or so. It just doesn't sound as though that's the kind of information sharing, at least, that's going to lead to effective oversight. Meredith, do you have a question? Sure.
I mean, just, with respect to the NSA surveillance memos, which, for the most part, we don't actually know what most of them say. We do know some little bit, and I think what we do know suggests that there really was inappropriate information sharing. We know what Senator Whitehouse has told us from very small portions that he managed to get released, which is that, they include the conclusion that the president doesn't have to follow the law or his own executive orders. We know that before Jack Goldsmith arrived at the Office of Legal Counsel, not even the National Security Agency, and that's the real NSA, not even their general counsel was permitted to see the justification for the program or some of the legal basis for the program. It's sort of hard for me to imagine that the NSA's general counsel should have been treated like, a member of Al-Qaeda. If anyone should have been able to see all of those memos, you would think it would be the agency that was being asked to conduct this kind of surveillance. And we also know that senior DOJ officials thought that at some times this program was illegal. And so again, the secrecy, which is what I was sort of saying in my opening remarks, is what allowed it to happen despite all of those things that are troubling that we know today. And I think the result is what Jamie Gorelick said yesterday on the opening panel at this conference, which is that now, companies that are being asked to help out the government probably are going to respond, well, I don't know, let me think about it. Because instead of feeling that these programs have been fully vetted and are legitimate and are needed, they are going to have to ask that question. All these companies are now being subjected to lawsuits out in California about the fact that they participate in these programs, and they're spending a lot of money on lobbyists right now trying to get immunity and all of that. I'm sure most of those companies would have preferred to avoid that whole mess if they could have.
Going back a minute to Richard, you answered my question, but I didn't give you a chance to, if you want to address anything that the other panelists said or make a comment on it. Go ahead.
I'd be interested in just hearing what Professor Stone thinks about what happens when information does get to the press when is it appropriate or not appropriate for the press to go forward, and should it practice some self-restraint? I think, in retrospect, most people think that the New York Times made the right decision to release information about the TSP, that the mere fact that there was such a program didn't provide any real intelligence to al-Qaeda, and it is something that probably served the public well to get that information out there. On the other hand, I think of a situation that came up at about the same time where the Washington Post published information essentially saying that there were secret prisons that were being maintained in Romania and Poland. And while everybody knew that at the time there were somewhere out there that prisons were being maintained for the benefit of the CIA, it had never been officially disclosed where they were, and the result was to cause very serious diplomatic problems between the United States and European allies, and it caused a huge amount of problems for both Poland and Romania to have this kind of information released. And I guess if you're in the press and you're trying to do your best to undercut American foreign policy, well, then maybe you think it's a good thing. But I'm wondering if that's not the intent of the press, but rather the intent of the press is just to simply report that information that it thinks is in the public interest to be known. Is there an appropriate role for self-restraint by the press in, for example, the situation I raised?
That's a good segue for you to answer and then go on and pick up anything you want to. A question I would have asked you, but cover your own agenda first, is since you wrote an issues paper on all of these subjects, if you were called in by President Obama / McCain on the first day and said, I do want to have an open, transparent government, what are the things I can do in the first 100, the first 1,000, the first year that are going to be significant steps toward that goal?
Yeah, well, first, of course, I believe the press should exercise judgment, as they always do. I mean, all of us who have rights exercise those rights in ways that we think are responsible, as we should. The mainstream press, I think, has lots of self-interest, including professionalism and commercial economic self-interest, to behave in ways that are thoughtful and respectful of national security. The New York Times and the Washington Post would be out of business fairly quickly if it actually did things that seriously jeopardized the national security, and the government could demonstrate that. The larger issue, I think, is not the mainstream press. I think that in a world of Internet, we have now the capacity for the instantaneous dissemination of information by individuals who are not part of the mainstream press, who are not part of the profession, and I think that does create a very different type of issue. So I would worry much less about the New York Times and the Washington Post than I would about the possibility of the instant dissemination of information that can't be put back in the bag again, and I think that's just part of the reality of the world we live in going forward. But I wouldn't be losing very much sleep over the New York Times or the Washington Post if I were working in the National Security Agency right now. And I do think it's important to note that in all of American history, it's very difficult to find any compelling examples of cases in which the press has in fact published secret information that the government has claimed seriously interfered with the national security. The single instance of that is sometimes invoked is during World War II, when the Chicago Tribune published information from which it could be discerned that the United States had broken the Japanese code. And the administration, Roosevelt administration, didn't pursue that because the Japanese didn't figure out from the story that they could have figured that out. And they obviously prosecuting the Tribune or doing anything else against the Tribune would have simply called attention to it. But that's the only historical instance I know of where there really was a plausible case of a serious harm to the national security caused by mainstream press in this regard. With respect to what I think the next administration should do, I think the single most important issue is the one that Meredith discussed. That is that we do have classification run amok. There's almost no one who has spent any time inside the executive branch in the last 50 years who doesn't come out of it saying that, regardless of whether they're Republican or Democrat, whether they're conservative or liberal. All of the incentives are to overclassify. And that's an area where I think great attention needs to be paid. I think the Clinton administration made real progress in that regard. which was reversed, as Meredith explained, in the Bush administration. As I said at the outset, I think the right question, at least in the first instance, should be not would the disclosure of this information conceivably harm the national security, which is essentially the question that is now being asked in classifying, but whether, in fact, the disclosure of the information would be likely to harm the national security more than it would be likely to be of value to the public, which was closer to the question that was being asked in the Clinton administration. And it seems to me that's by far the most important step. That would alleviate a lot of the difficulty if that change were made. Everything else, I think, pales by comparison.
Do you have anything else you want to pick up on
okay.
that other panelists have said? Okay. Meredith, and let me just lead into following what Jeff was talking about. Since I know you're dealing right now with that very issue of what kind of reforms of classification would be you would recommend to the next president, maybe if you haven't classified that information within your office, you might give us a few substantive indications of where it seems like such a technical thing. But from what I read in the paper, a lot of it has to do with implementation too. There was an article recently pointing out that not every, but many agencies classify differently. They not only define what damage is, what serious damage is differently, but they have wholly different kind of procedures even within the classification order. And so there may be an administrative problem as well as a substantive problem. But anyway, anything you have to say on, I agree that is the overriding priority.
Right. Well, I mean, I think Professor Stone touched on a very important part of it, with his argument for a balance in the classification executive order. I mean, there is actually one provision of the executive order that would permit consideration of public interest, but it's really only been invoked in very limited number of times and basically by the president. And really that balancing needs to go a little bit further. I mean, for example, it's been invoked in order to release the presidential daily brief that said bin Laden was seeking to attack the United States. So, there are certainly instances where classified material is authorized to be released, but that balancing needs to go much further. And there's a number of things that I would certainly bring back in that were in the prior version of the executive order. Beyond that, I think we also see a need to have more internal checks on overclassification within the agency, actual audits with consequences such as the loss of your classification authority, because that's a very important thing for people, and then retraining before you can get it back. There also needs to be internal classification, declassification boards in agencies. We have seen repeatedly in instances where there are independent boards that look at classified issues that result in more information coming out. For example, there's examples like the JFK Assassination Records Act, the Nazi War Crimes Records Review Act. In all those instances, there were boards that included historians and members of the public who were able to really push for more declassification of those specific types of information. So that concept could be used going forward within each agency. So I think those are some of the specific things that we would recommend. In addition, I really think the issue of judicial deference is one that needs to be addressed. And it may not be that that's a change in the law, but it needs to be a change in the way judges look at these issues. Because the reality is that no matter what anyone says, I know of really no instance when a judge has ordered a secret to be released. What judges have done, though, and what judges can do, is they can really push the agency to explain themselves. And I think that's one of the things that's really positive about these proposals to reform the state secrets privilege and how it's being employed by the courts, is that it lets judges know they have these tools. I mean, I would argue the judges already have most of those tools, but they don't use them. So maybe spelling them out will actually help the judges to do that.
One additional thing we haven't had time to take up, but it's closely related, would be the FOIA thing, of course, because the FOIA internal memorandums have changed from administration to administration as to whether or not the presumption for the person who's making the decision inside the agency should be in favor of keeping back whatever you can or putting forth whatever you can't actually indicate or show what the harm will be.
Right. Well, just to briefly touch on that, Janet Reno, when she was Attorney General, issued a memorandum that said basically that agencies should have a presumption of releasing records unless there was a foreseeable harm in their release. And what that meant was for certain types of records where the agency had discretion, including a lot of deliberative process records, the agency could choose to release it because there wasn't really any harm in releasing it. No need to keep it secret. Attorney General Ashcroft overrode that and changed the policy to say if there's any basis for withholding it, the record, then it should be withheld, any basis. Well, of course, that did have an impact on what agencies are doing. I mean, some people would say when you get to court, it hasn't made much of a difference, but I mean, I will say from my organization's experience, and we've filed 30,000 FOIA requests in our 20-some-odd year history, that it made a difference with how they respond to ordinary FOIA requests. So I didn't have that, I didn't mention that, you know, revising that memo in my statement before, because I was really talking about classification, but I would say number 2 on our list would be that the President should issue a presidential memo directing his Attorney General to issue a new FOIA memo, and that FOIA memo should certainly return to the presumption of disclosure that was in Janet Reno's.
Yes, go ahead.
And then to
Go
make
ahead.
it, I mean, it's also important to see what happens with the culture of secrecy. On the one hand, we're focused here on millions of individual documents, which individually may have no great consequence either to the national security or to the public knowledge. But what happens is you wind up with the government trying to keep secret, and for all we know in other respects, keeping secret, substantive policy decisions like the authorization of the NSA to engage in surveillance that involves American citizens, or the use of interrogation methods that would otherwise violate national and international law, or secret prisons. There's nothing about those policy decisions that requires them to be kept secret. Nothing whatsoever. They can be debated, they can be discussed, they can be tested in court. It's the excessive obsessiveness about secrecy that's used to try to shield those policy decisions from public view, not because there's anything about national security in the secrecy, but because they don't want to have the debate over the discussion. And they don't want people to know that they're doing these things because politically it might be complicated. And that's a real problem. And to me, that's the most fundamental issue that, in terms of accountability and transparency, we have to keep in mind here. This is not about 8 million documents. It's about fundamental policy decisions that are being made in secret that are not constitutionally made in secret.
That's just to add a footnote to that. I think the Fritz Schwartz book, Unbalanced and Unchecked, makes an interesting point about that very thing, and that is that basically that secrecy allows the executive to make changes in the law, fundamental changes in the law, such as definition of torture, the permissible techniques on interrogation, without Congress knowing about it, without anybody knowing about it. So in that sense, it subverts the entire separation of powers process on there. Well, we've got at least 15 minutes left for audience participation. Let me tell you how we're going to do it. Somebody wants to ask a question, stand up, and the young lady will approach you with the microphone, and you can go ahead. All right, we'll start here with, oh, you've got the microphone. Okay, how about this lady in the white blouse? Make sure I can see with the light. Okay, start. Okay, go ahead. And if you want to address it to a particular panelist, do so.
Actually, this is for the, is this on? Okay, this is for the whole panel. My question has to do with the state secrets privilege and what to do, what your thoughts are about what to do in the situation where you have evidence that actually is a state secret and it's been found validly, it's been looked at by the judge, it's found to be evidence that could harm the national security if it's disclosed, but it also reveals massive wrongdoing on the part of the government, violations of civil liberties, you know, a profound systemic problem in the government. And, you know, and just to sort of forestall the obvious response, I'm not sure that congressional oversight is really the answer in these cases because, you know, if, for example, if you take the warrantless wiretapping program, the rationale that the government gave for that was we don't have to follow, you know, the public rationale in the white papers was, you know, Congress can't tell us what to do. We have a separate Article II authority that Congress can't touch. So in that situation, Congress can't legislate its way out of this. They can't just pass FISA again. So in that situation, what you need is a court to say you don't actually have that Article II authority. But if the evidence that would allow the case to go forward would actually harm national security, where do you go from there?
That's a really tough question. Go ahead. Either, both of you. And
I would say,
take a
first of
stab
all,
at it.
there may be appropriate times where Congress could go into court if it wanted to, as an institution, and if it really were Congress against the executive branch, perhaps that might be an appropriate time for the courts to intervene. Other than that, you've got cases where individuals are claiming that, well, maybe, I don't know, but maybe somebody did wiretap my phone conversations, and I want to be able to go in court and figure all that out. And as the Sixth Circuit appropriately held in that case, there is no standing if you don't really know that you have been injured. Then what happens? Okay, well, I think I do have evidence that I have in some way been wronged. Well, the fact is you may have that evidence, but presumably if that evidence is a state secret, it has not been revealed, and perhaps the government has evidence that would show your evidence is wrong. But they can't reveal that evidence without revealing another state secret. And that is why the courts have uniformly said throughout the history of the state secrets doctrine that that's not an appropriate reason to allow the case to go forward simply because it's your claim that the government acted inappropriately. So that, in fact, Congress does have lots of means of oversight, including with its appropriations powers, including with its subpoena powers, including its investigation powers, so that that really is the answer.
Well, wait, let me just follow through. Take the El-Masri case. I mean, you've got overwhelming information that the guy was subjected to extraordinary rendition and suffered injury. Case was immediately dismissed. I mean, very few people, I'm not even sure the government would say he wasn't injured, but yet he can't, you know, he has
Well,
no
just
form.
let me just go through a few
sure.
facts of that case. This is not the case of the Canadian. This is a German who
Yes,
was
I'm
traveling
sorry, I mixed
to.
it up with Amari, right?
Yeah,
but
he was traveling in Macedonia,
Right.
and he was picked up by the Macedonian government. He was taken by the United States to Afghanistan, where he was interrogated. The government, from everything I know, denies that there was torture involved, but he says, well, it was torture. Well, that would be something that would have to be revealed in court if his case were allowed to go forward. He was picked up by the Macedonian government. I think the last thing that they would want to admit, the Macedonian government, is that they fully cooperated with the American government and turned over somebody from their country to the American government, so that the mere acknowledgement that those sort of things took place would be the kinds of things that would cause diplomatic problems. And the Fourth Circuit read the confidential in-camera memorandum that I didn't see, and I don't think anybody here has seen, and concluded that it would be inappropriate to let the case go forward. That's not to say that if, in fact, as the allegation has been made, that this was all a case of mistaken identity, that he never really was the al-Qaeda operative that the CIA thought him to be. That's not to say that he can't be compensated, and it would seem to me that it would be wholly appropriate for Congress, if it wanted to set up some administrative body that could take into account those kinds of claims secretly, but it has never been the case that we've allowed those kind of cases to go into open court.
Jeff, did you want to say something else?
Well, it's an interesting contrast to the Pentagon Papers case. In the Pentagon Papers case, the government's argument, among others, was that the disclosure of the Pentagon Papers would reveal the fact that other countries had participated with us in the hostilities in Vietnam in ways that it was necessary for American national security to keep secret, and that revealing this information would undermine our alliances and undermine cooperation with other countries. And the court said that's just not enough to justify a restraint on the revelation of the information. It's essentially the same argument that's being made here as a state secret, cast in state secret terms. It seems to me that if a plaintiff can make a reasonable showing that the government is engaged in unlawful or unconstitutional action, and the government's only claim against litigating that is the fact that it will be embarrassed or other countries will be embarrassed because their secret deals with us will be made known, that's a perfectly appropriate matter for the courts to decide and to let the litigation go forward. Sometimes we're embarrassed, and so sometimes our government can be embarrassed. If we make deals that we don't want to be known publicly, that's the price you pay.
This gentleman down here who's going to talk about state secrets, I believe.
I have a question for the panel, but particularly for Mr. Sam, and it follows on Mr. Stone's last remark, actually. The legislation in the House and the Senate really has three central aspects. One is the amazing proposition that a judge should see the evidence before it rules on whether it's privileged. And judges have not done that in a lot of cases, although they've gotten better. The second, and Judge Wald alluded to it, is moving the case along, not dismissing it out of hand, but doing everything possible to see if the litigation can go forward. And another aspect of the process, making it adversarial as much as possible. But the key thing at the end of the day that's been referred to is the standard for when the judge, or how the judge should treat the analysis of the government. And I think your comment, and I do have a question for it, I think the comment that you made is the fallacy of the government's position by structuring the issue as the judge's expertise versus the Pentagon's expertise. But if the head of the EPA makes a predictive judgment about what a dam is going to do to the environment, the judge gives it a lot of weight, but he obviously doesn't rubber stamp it. And in both bills, although they differ slightly, there's procedures for the judge to appoint a master, a court-appointed expert, a guardian ad litem, or in some cases with the appropriate counsel to clear them. And my question is the following hypothetical. If you're a judge and in a diplomatic case, the Assistant Secretary of State for Europe, or in a defense case, the Assistant Secretary of the Air Force for Acquisition is giving you all sorts of explanations why the material should not be released. And the district judge has appointed former Secretary of State Powell or Secretary of State Gates after he leaves the Defense Department as an expert. What weight should the judge give the Pentagon or State Department assessment of the dangers versus Powell or Gates? In other words, should it really be any different than a case where there are expert witnesses on both sides?
Yes, it should. Now, I'm not totally against the idea of a judge being allowed to get somebody to be of assistance in a case if the person has the sufficient security clearance. But the fact is, anybody who is out of government is not going to know all of the particular ramifications of that particular case. Judges all the time pay deference to the expertise of the government, so that it's not just a matter when the government goes into court where they weigh one expert against the other. All the time, courts say that we defer to the expertise of the particular government agency involved on the understanding that we can't possibly know quite as well as them. That's not to say that courts in administrative law don't all the time take a close look and do their best to try to make sure that they have all of the evidence. And so it may be that getting a special master would help them in certain cases to get all of the evidence. And certainly I agree with you that it should almost always be the case that the judge looks in camera at the documents that are available.
But in this situation, the hypothetical I gave you, Gates or Powell would have seen the evidence also, one. And two, even if they don't know absolutely as much about the factual details, what weight would you give their response or their analysis of the arguments being used by the government, which they presumably would have a lot of...
Well, I would assume that Powell would be able to give me some good questions to ask the government people so that I would be able to take the hard look that we take all the time in administrative law questions. But at the end of the day, it's got to be a deferential standard that the courts use so that if the government agency involved is saying that we have taken a careful look at this and you've seen all the evidence that we base this on, that the court just simply can't be in a position of saying, well, thank you very much, but I'm going to use my superior knowledge that I've gained from Mr. Powell and going to come up with a different conclusion. That is not the way we have done it throughout time, and I think it has worked well under the current system.
Okay, quick comment.
Okay. I'm just going to quickly comment on that. I mean, the reality is that if you read the cases, in fact, judges give deference all the time. And in the FOIA context, when you're dealing with classified information, even though Congress has specifically said de novo review, in-camera review is permitted. Judges still give deference. So if you write legislation that says, Judge, please give deference, well, then that really means there's not going to be any review at all. So there needs to be some very, very hard thought given to how you articulate what a judge is going to do. And, I mean, the reality is, in cases, if I went out and hired Secretary Gates the day after he retired and had him file a declaration on one of my cases, what a court would do today under the case law is it would get no weight. And that just simply doesn't make any sense.
And another way to think about this is to adjust the certification that the government has to make to which you give deference. So, for example, if the government has to say, well, the disclosure of this information could conceivably injure the national security, that's one statement. The other would be, well, the disclosure of this information will immediately create grave harm to the national security. There are all different ways of at least articulating what it is the government needs to certify, which could affect, to some degree, not the level of deference, but the standard that the government has to state is present in order to merit that deference. So that's another way of giving courts a more aggressive role in it without having to actually try to independently evaluate the evidence, but at least by demanding that the certification be a more demanding one.
Okay, we've got time for at least one more question. How about this gentleman down here?
Okay, well, this is similar in terms of disclosure addressed to Professor Stone. It's kind of a hypothetical. So I'm assuming the Free Flow of Information Act is passed, it's qualified, and it has the national security aspect. There's a newspaper story that's printed. Government wants to find out the leak, the trial, a motion. At the motion, the government wants to prove national security so that the privilege is not there. And it sets forth an affidavit. In setting forth the affidavit, it says, no, the journalist counsel cannot see this, only the judge in camera, and it's not given to the counsel, to the journalist, which was the case in Judith Miller with the Judge Hogan. So under this free flow of information, any better opportunity for the journalist counsel to see this affidavit, assuming it's going to be held in secret, because it's now an enforceable right?
Good question. I honestly don't remember the terms of the legislation on that specific point, but I don't think it provides anything about that issue. I think it basically treats it the same way it would any other privilege, which means that this is not evidence being introduced into court for the ultimate decision in the matter under dispute, that is the criminal trial or the civil trial, that a judge can consider otherwise inadmissible evidence, and that would include, presumably, evidence on national security that wouldn't be disclosed. So I would assume that the statute doesn't address that question.
Okay, I think we have time for one last one. Okay, this gentleman in blue.
Question is for Mr. Samp. How do you respond to Professor Stone's point that a lot of the problems that we've had, at least in this administration, revolve around policy decisions that were made behind closed doors? And, I mean, fundamentally, we're a democracy, and a lot of these decisions, had they been aired out, we may be in a better position now with our foreign relations and internationally and our standing in the world.
I hesitate to answer because it would go into whether or not I agree with your basic premises about problems with this administration, and I don't really want to do that, other than to say I think whether you like some of the policies that have been going on or not is somewhat different from the issue we have been discussing today about the state secret doctrine, that the doctrine has to do with whether or not exposure of the details of that program would cause problems for the country, as opposed to whether the problem is a good one in the first place. So that's an issue to be discussed at another time. What I'm suggesting today is that the cases that have been decided pretty much unanimously up to this point that say that when the defense of a lawsuit would require the disclosure of the entire program to the detriment of the country, that those decisions were all decided correctly, and we don't really need to be changing the state secret doctrine.
I'd just add something to that. If you're talking about what I think you're talking about, such as some of these, OLC memorandum on policy decisions, on interrogation, et cetera, I think that I think there's a very reasonable argument to be made, you know, that they shouldn't have been classified if they, I haven't seen the actual document, well, I've read about them, but if indeed they describe policies and not factual details of particular episodes or anything like that, if it's a general policy that's being described, then it really, you know, should not have been subject to the National Security Act. And whether or not, you know, the Abu Ghraib, after it was disclosed that those things had happened. So those I think go back to, and if people do keep them secret, and I think it goes back to Professor Stone's point about the culture of secrecy, which clearly was from the top on down as to those particular instances. And one can, I guess, only hope that through our political machinery we will elect somebody who has a more, who doesn't have an extreme culture of secrecy. Okay, I am supposed to tell all of you that we hope you will join us at 7 o'clock this evening for our banquet. There's going to be actually, I hope, an interesting discussion between 4 Court of Appeals judges, of which I am one. And volunteers will be on site to direct you to the appropriate location. So we hope we'll see some or all of you.